House will come back to order. This House will come back to order. Had a little bit longer of a lunch break, but time to go back to work. Clerk will ring the bell. Clerk will read the caption to a group of privilege resolutions.
Recognizing and commending Harris Dean Jaggers. Recognizing and commending Ryan Patrick Coates. Recognizing and commending Dr. Thomas Curran, Dean of the College of Southern Polytech College of Engineering and Engineering Technology at Kennesaw State University, and students Valerie Washington and Kurt Jacobson for earning 3 of the top 6 annual awards from the Georgia Society of Professional Engineers. Recognizing and commending the students, coaches, and staff involved with the inaugural football season at Kennesaw State University. Commending Mr. Gunnar W. Daniel on the grand occasion of his 100th birthday. Recognizing and congratulating Mr. Brian Finicum on the occasion of his retirement. Congratulating the Alatoona High School Buccaneer football team on winning the GHSA 5A state championship, and for other purposes. That completes the reading of the privilege resolutions.
Is there objection to the adoption of the privilege resolutions? The chair hears none, and the resolutions are adopted. All right, we're about to go on the rules calendar. I just thought y'all might be interested in knowing, spring training is starting, this week down in Florida? That means that those of us that look at box scores every day will soon be able to enjoy that pastime. We have a box score. As of lunch today, this House had passed 18 bills. Chamber across the hall had passed 2. Clerk will read the caption to House Bill 171. House Bill 171.
House Bill 171 by Representative Hightower, the 68 and others, to be entitled an act to amend Chapter 3, Title 1 of the Official Code of Georgia, annotated, relating to laws and statutes, so as to revise provisions relating to the effect and enforcement of foreign laws. And this bill having been referred to the Committee on Judiciary, that committee recommends that this bill do pass by committee substitute.
Chair recognizes Representative Hightower to present the bill.
Thank you, Mr. Speaker. I bring before y'all today HB 171. This bill has been a bill that I have been working on for about 4 years now. It is a culmination of a lot of effort and a lot of work through the Judiciary Committee. With the help of Chairman Willard and many from many different areas, what you have before you today is a way to help protect Georgia citizens in the forum nonconvenience area of our code. What this does, whenever a court is looking to transfer venue, in other words, someone has a lawsuit against them and someone is wanting to move this case out of our state or to another country, the courts will look at several factors before they allow that case to be transferred. What this simply does is add one more factor for the courts to look at when making that decision. And that new factor is found on lines 29 through 31. And it essentially says that before the courts will transfer a case to a different state or a different country, they will look to see if the place they are transferring the case to requires due process of law as is required under our Constitution. We're doing this in order to protect our citizens if a case is moved outside of this state. And that's simply what it does. Early on, this was had opposition from the business community and the arbitration group here in Atlanta. But I sat down with both those groups and worked with them at length on this. And this is something that they actually now speak in favor of and even testified in committee to support this bill. So we've worked on it for quite some time, and hopefully this is something that everyone feels comfortable with now. And I'd ask for your favorable consideration. Mr. Speaker, I'll yield for questions.
You have a question if you do yield. Chair recognizes the chairman of the Judiciary Committee, Chairman Willard, to your right for a question.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes, sir.
Representative Hightower, is it true that we currently do have a provision in our law that recognizes the need to have the courts of our state apply our laws as a superior to the laws of any other country, et cetera, correct?
That's correct. We have a provision in our code that actually states that almost directly.
And what this does it not, is complement that provision and as to the issue about transferring of cases?
That is correct.
And it's true, as you said, this has been something that we've hammered out. We've got the support of the various business communities, the courts, and the International Arbitration Group is what we've done.
That is correct, Mr. Chairman.
Thank you, sir.
You have no further questions.
Mr. Speaker, I'll yield the will and ask for your favorable consideration for HB 171.
Gentleman has yielded the will. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 171 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 171. The ayes are 165. The nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 727.
House Bill 727 by Representative Battles of the 15th and others to be entitled an act to amend Chapter 10 of Title 25, the Official Code of Georgia annotated, relating to regulation of fireworks, so as to revise provisions relating to the sale, use, or explosion thereof. This bill having been referred to the Committee on Regulated Industries, and that committee recommends that this bill do pass by committee substitute.
Chair recognizes Chairman Battles to present the bill.
Thank you, Mr. Speaker. I'd like to preface the remarks that I have as to the bill I'm presenting today. You also have an amendment that is in your package that is AM 410156. So just as we go through this, you can understand what the amendment does. I will let you know that I do support this amendment to this bill, and I hope that you will agree with me. As everyone that was here last year realizes, we passed House Bill 110, giving the rights to sell fireworks in Georgia, and I believe it was a good piece of legislation, that I voted for. I'm glad to see the revenue coming in from that. But for House Bill 110, it fell short as to the regulating authorities that would oversee the permitting and the sales locations and the health and public safety issues that was not in House Bill 110. Therefore, it was necessary to fix that problem, and I believe that House Bill 727 does just that. What does 727 do? Well, when we began to move through last year and began to hear from our constituents in our local areas as to how the fireworks bill was being implemented, the use of those fireworks, we found that there was a lot of abuses, and the question came up as to who was overseeing this, who was actually in charge of taking care of certain issues, safety issues, noise ordinances, and other issues that we did not designate someone to be in charge of. And what we did is in this, there was two things, or actually there's three things in this bill that is in the original bill that we drafted. Those issues are this: we need to allow the public governments, such as county governments, municipalities, and combinations of those two when they have a governmental agreement, and that might be in the area of their fire department that would be overseeing these fireworks sales locations. There's also in this legislation is that the governor of the state of Georgia, Environmental Protection Division of the DNR, would also be involved in looking at the possibility of maybe eliminating or not allowing fireworks to be used if in fact the state of Georgia was declared a drought area. So that's a safeguard to make sure that we do not have fires in locations that maybe would be consumed very quickly because of the dry conditions. So that local authority really deals with a couple of issues. First of all, they would actually do the permitting of that location where fireworks will be sold. Also, the local authorities would be in charge of the health and public safety issues. Those health and public safety issues are something as to the effect of noise ordinances. And so the local governments will draft their ordinances based on the location. As we know that our communities across Georgia are different. They're all different. Some are very heavily residential. Some of them are very rural. And we should give our local governments the ability to have control in the provisions of those areas that brings us concern. There is also there are several areas that we have in the piece of legislation that you have before you, and that is in areas where there is a restriction that you cannot use or use fireworks in certain areas that are too close to a wall that could actually ricochet off, could go into a place where you would rather that it not go and cause either personal or public harm. And the other was that as what happened this past year, some were setting off rockets underneath bridges. And as you know, that once a rocket hits a solid object, there's a lot of sparks that can fly and could be injuries as well as property damage. It also eliminates the ability to use governmental properties for fireworks that unless they have permitted them themselves, those governments can do that permitting themselves. Like if you have within a park in your community, they can permit that, but most of the time that is not for consumer fireworks, and this is what this bill deals with, is consumer fireworks. Most of those that would be in a park would be under a different category, which would be, of course, commercial. The other issue, and you can find that in the bill, but the other issues are this, is that as it would be of someone being in a car or handling some object that could cause harm to someone else, using a firearm, we felt like that someone who was actually using fireworks that was intoxicated, and that intoxication level would be 0.08, and that is the once it goes over that, it's illegal in many cases. They consider you intoxicated. It also gives protection against those who might be using fireworks and they're under the influence of drugs. So giving local control to be able to determine those locations of sale, meeting the local ordinances that will be drafted by either the county, the city, or those combinations, will be able to monitor and to control those situations where there might be some fireworks used that would bring harm. There's one other thing that that this bill does, is that it also provides for a 1-cent excise tax that would be collected and paid to the local governments. Now, the way that we offset that in this legislation proposes that the sales tax will be reduced by 5% to 4% and collect the 1% of the excise that it will go to the local governments. And Mr. Speaker, that is the essence of the bill with the amendment that has been proposed. So I will stand for questions, and if not, I would ask that you favorably consider voting yes.
You have questions if you care to yield.
I would have been surprised if I had not.
Chair recognizes Chairman Benton to your left for a question.
Thank you, Mr. Speaker. The gentleman yield.
Yes, sir.
The question about temporary structures for selling fireworks, is there anything in the bill? I have looked through here and I saw where there was some wording for that, but is there any prohibition on temporary structures, since fireworks is a temporary or a seasonal item?
That will be handled in the amendment that was made in rules. The portion, and if you will find it on line 28, it would exclude tents, canopies, and membrane structures. Those are, in the amendment, would be removed.
Well, gentleman, further yield.
Yes, sir.
So in other words, if you have a small business owner that is putting up a temporary tent to sell fireworks 2 or 3 days a year for those seasonal, in essence, are we not deciding who the winners and losers are going to be on the sale of fireworks?
We are. If the instance of that being added, this was amended into the bill, as it always, as Tom remembered, it was tack on. This is one of those bills you get to tack on. And
We know what happened to that bill, don't we?
we sure do.
Okay.
And but that was added to the language, and then through the process, the amendment in rules was to remove that, and that will be a decision that will be made by this body.
Well, gentlemen, further yield.
I do.
It just concerns me that we are picking winners and losers, and we are telling small business, in this case, that you can't set up a tent to sell the goods out of, that you're going to have a permanent structure. Is that not true?
It is, but I think the reason for that is there was the question of whether or not they are safe, fire safe, and that could be handled under local control. But the amendment that you have right now is to strike that portion of it.
All right, thank you.
I'm lighting the fire, but I'm going to take one more.
One more, okay. Chair recognizes Chairman Welch to your left for a question.
Oh, there you go.
Does the gentleman yield?
Yes, sir, I do.
Chairman, in accepting or adopting the amendment, we are still preserving local control as it exists today and as it has existed since last year when we adopted the fireworks bill from last year. Is that not control? Is that not true?
Yes, sir, that is true.
And is it also not true that there has been concern raised by members in the committee that there's concern about collecting the revenues from the sale of these fireworks at tents, given that they are temporary in nature and that they may or may not remit those taxes back to the state as is contemplated under the fireworks legislation? Is that not true?
That is true. There was concern about knowing whether or not they were paying sales tax.
Thank you, sir.
All right. All right. Mr. Speaker, I believe I'll yield the web and give opportunity to have, well, my friend who actually had the amendment is not on the floor, but I yield the well.
Gentleman has yielded the well. Chair recognizes Chairman Taylor to speak to the bill and the amendment.
Thank you, Mr. Speaker. As the chairman of the subcommittee and being on the committee that handled these, this bill was extremely well vetted. Chairman Battles and I worked on this for a long time to get 727 out as a clean bill. I'm not going to rehash everything he said. Basically, the fireworks bill from last session prohibited temporary structures. The House Regulated Industries Committee, and we did follow a strict committee process, subcommittee, full committee, vetted this extremely well, put two bills together, and recommended a do pass. Again, I'm going to applaud my friend Mr. Benton. The state should not be picking winners and losers. Basically, if you look at any other industry, if I drive down to South Georgia, you see boiled peanuts by the side of the road being sold from tents to temporary facilities. You see apples, you see fruit stands that are temporary like this. What this bill does is gives that control to the lowest common denominator, whether it's a county or a city, or a municipality. If you don't want tents in your city, you can ban them, but it's like many other things. Not all parts of the state are the same. This proposed amendment, again, picks winners and losers. It protects another entire class of retailers from having to compete with against seasonal tents. Georgia law should provide for a level playing field for everyone, and not picking out a certain part of an industry. Tents are relatively safe. They have the same requirements for fire protection under the National Fire Protection Act 1124 code. The locals can put that, can even make that more stringent. It has to be flame retardant, have to have a maximum 75-foot travel distance to exits, have a minimum of 2 exits, have emergency lights, have lighted exit signs, no smoking signs, and a minimum of 2 fire extinguishers. This is a very common way throughout the United States to sell consumer fireworks. Again, I guess the point I'm trying to make here is we allow many other industries, and the argument for the revenue, you know, if I'm buying honey in North Georgia or onions in Vidalia out of the back of a pickup truck, that is no more regulated than this. And with that, Mr. Speaker, I will be voting for the bill, but I am going to vote no on the amendment. I ask you to do the same. Mr. Speaker, I yield the well.
Gentleman has yielded the well. Chair recognizes Representative Beskin to speak to the bill and the amendment.
Thank you, Mr. Speaker. I too rise today in opposition to the amendment and in support of the bill. In opposing the amendment, I am saying that I support the concept of the ability to sell fireworks from seasonal tents. We all know last year we approved this fireworks bill, essentially establishing a new business here in Georgia. And if we were to say now that we would not allow sale of fireworks from tents, as was under the proposed HB 727 when it came out of committee, we would be providing a barrier to entry to smaller businesses who would be able to enter the market. The temporary structures, the tents, are required to comply with the NFPA 1124 code. That stands for National Fire Protection Association code. And it has very stringent, very detailed protections set forth here in that code. These tents have to comply with the Life Safety Code. They have to comply with the Child Safety Act of 1966. They are not allowed to sell pest control devices under these consumer retail tents. They have to comply with the U.S. Consumer Product Safety Commission. They have to comply with regulations under the U.S. Department of Transportation. They are required in the bill, if we do not adopt the amendment and we don't strike out the provisions in the bill, they are required to be within 1,000 feet of a fire hydrant. The distributor must be licensed. In addition to having to comply with the NFPA 1124, they have to get a tax ID number from the Department of Revenue. They have to pay a license fee of $750. And this is important. These tents are only seasonal. They can only be standing between June 18th and July 6th and between December 20th and January 1st. And remember that all of these vendors would be a 1% excise tax of all the fireworks sold would be returned to the local community. So when you look at the bill as proposed with the amendment, there undoubtedly would be fewer fireworks distributors. They would be only those who have permanent locations, and permanent locations can have up to 2 temporary locations. But those locations must either be in the same county or within 75 miles of a permanent location. So I would suspect there are many counties here in Georgia that would not qualify for a temporary structure unless we were to reject this amendment and allow the use of seasonal fireworks tents. And I urge you to vote against the amendment and for the bill. Thank you.
You have a question if you care to yield.
I will.
Chair recognizes Representative Pizol to your right for a question.
Thank you, Mr. Speaker. Does the lady yield?
I do.
Is it not true that anyone that claims to support free market principles should vote against the amendment and support the bill?
Well, that occurred to me. I would agree with
Thank you.
the gentleman.
No further questions.
Thank you.
Lady has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. There is an amendment. There is an amendment. It is AM 410156. Clerk will read the amendment.
Amendment offered by Weldon III and Battles of the 15th, AM 410156, is printed and distributed and in your books.
Is there any objection to adopting the amendment? There is objection. Does the gentleman move? Gentleman moves. All those in favor of adopting the Weldon Battles Amendment, AM 410156, will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine. On the adoption of the amendment, the ayes are 51, the nays are 121. The amendment has failed. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 727 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 727. The ayes are 165, the nays are 8. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 513. House Bill 513.
House Bill 513 by Representative Stevens of the 164th to be entitled an act to amend Article 3, Chapter 11 of Title 9 of the Official Code of Georgia annotated relating to pleadings and motions so as to revise provisions regarding the procedure for claims asserted against a person or entity arising from an act by that person or entity. This bill having referred to the Committee on Judiciary Non-Civil, that committee recommends that this bill do pass by committee substitute.
Chair recognizes Chairman Stevens to present the bill.
Thank you, Mr. Speaker. You may recall last week we had a lot of people up in this part of the gallery that were from all over the country. They were from places like Sony, Paramount, Warner Brothers, and on and on and on. The people that generate this $6 billion film industry in this state. Well, they came to us. In fact, they came to us last year. And they asked us to help them with some really serious problems, as you might imagine, being the celebrities that they are, always wide open for frivolous lawsuits. And I thought I'd show you one. I think he's going to put it up on the board here in just a minute so you can get some idea of what this bill really is all about. What you're seeing here, and I watched this all the way home with my granddaughter several times from Atlanta last week. Pretty sick of the movie, by the way, by the time you see it over and over again. But this is an example. This is Frozen. You might have thought that Walt Disney's Frozen was about a princess and a talking snowman, but it was actually about one woman's true life story, or so she's claiming, in a $250 million lawsuit. Isabella Tanakumi claims that the movie is not based on Hans Christian Andersen's fairy tale, The Snow Queen, but rather her 2010 autobiography about growing up in the mountains of Peru. Tanakumi claims Disney plagiarized and copied the story characters' plots from her book and turned it into Frozen, the highest grossing animated flick of all time. $250 million, folks. That's what this bill is about. It is to save, if you will, the industries from the phenomenal cost of these frivolous lawsuits and a judgment early on. But it does more than that. This bill expands freedom of speech, the First Amendment protections beyond government issues, the deterrent to stop the filing of frivolous lawsuits is at its core. The bill is requested by the Motion Picture Association of America to support the booming industry. Remember, $6 billion. Shortly after the lawsuit filed, the court trial will take an immediate review and determine the merits of his action. It provides for an option of the trial court to dismiss, and it provides for a quick review to avoid expensive discovery. The loser pays, which will help to keep the shakedown, and that's what this is all about. It's a shakedown, getting that check, those shakedown lawsuits out of the judicial system. It is strongly supported by the movie industry, broadcasters, the Press Association, and First Amendment advocates. Thoroughly vetted in the Judiciary Non-Civil Committee, the Setzler Subcommittee, and thank you, Representative Setzler. As of just a little while ago, it was unopposed by the trial lawyers, but I think now they've changed their mind some. It will send a good message. It will send a good message of support to the industry. It provides equal protection for a movie company, or ladies and gentlemen, even a part-time blogger. It will save expensive legal fees during the unnecessary discovery process. Mr. Speaker, that's probably as concise as I can make it. This is about eliminating frivolous lawsuits and stopping them hopefully early. Again, our industry is pleading with you. Florida did this last year. California has had this in for years. Ladies and gentlemen, if we're going to be the Hollywood of the United States of America and of the world, we're going to have to act like it. I would ask for your favorable support, Mr. Speaker, and I'll yield for questions.
You do have a question or two. Do you yield for questions?
As a pharmacist, if it's not an attorney, yes, sir.
Chair recognizes the chairman of the Ways and Means Committee, Chairman Powell, to your right for a question.
Will the gentleman yield?
Yes, sir.
Would you speak to the amendment?
There's somebody that's going to present the amendment.
Are you opposed or in favor of it?
I'm opposed to the amendment. It basically guts the bill. Thank you.
Do you further yield?
One more, Mr. Speaker.
Chair recognizes Chairman Willard of the Judiciary Committee to your right for a question.
Thank you, Mr. Speaker. To my friend in the well, do you yield?
Yes, sir.
This lawsuit you talk about, was this a lawsuit in Georgia or outside Georgia?
It was filed in Florida.
In Florida?
Yes, sir. Which is why I think they passed their bill last year.
Well, I'm trying to read the bill and get an understanding of this, what they call the SLAP legislation. We already have some provisions of this law on effect. And I guess the thing I'm looking at is in lines 63, 4, and 5, but it talks about once the court makes a decision, it's not a discretionary award. It may be it's an absolute award. The court shall award, as opposed to allowing the court to make the determination what and to what extent there may be an award. Is that right?
It is, and it's immediately appealable.
Okay. Thank you.
Thank you, Mr. Speaker. I'll yield the vote and ask for your favorable support and opposition to any amendments. Thank you.
Gentleman has yielded the well. Chair recognizes Representative Pack to speak to the bill and the amendment.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, I rise in support of House B 513 and against the amendment. Just to let you know, there's a couple things that I think got lost during the committee process. This bill, although it's supported by the movie industry, it's actually about the First Amendment. And if I could direct your attention to lines 73 to 80, which is the very important portions of this bill, our current anti-SLAPP statute protects statements, written or oral, made during legislative, judicial, or any other official proceedings of government. So in other words, if I were to say something about Chairman Stevens that's defamatory, I will be protected under the statute. And also, if you had opposition, when you speak against a zoning law or anything like that, during the proceeding, you are protected from being sued. Now, number two, in line 76, protects any written or oral statement made in connection with an issue concerning that's under consideration by a legislative, executive, or judicial body, meaning that you could actually speak about issues in a very strongly manner, long as it's an issue that's under consideration. So they could speak out there, and the lobbyist, for example, could say, this legislation is a piece of garbage, or in that person, the sponsor of the legislation is a SOB. They would actually be they'll be protected under this legislation. What our statute is missing, however, and is adding under the statute, is lines 79 to 80. This protects your written and oral statement made in a public place or public forum in connection with an issue of public interest or concern. And this is actually from the California statute. This actually protects the bloggers, those who show up on your Facebook page criticizing you, because it's not, if the statement on your Facebook page criticizing your action was not during an official proceeding, nor was it an issue concerning any issue that's pending right now in legislative session, they would actually be exposed to a lawsuit. This also protects whistleblowers. If someone who wants to blow the whistle as to their former employer violating the law, our current anti-SLAPP statute would not protect them from saying those things. Matter of fact, this happened in 2006 in Georgia. In a case called Berryhill versus Georgia Community Support and Solutions, a mother who had a child in the community support solutions blew the whistle on an online forum saying that their activities were not safe. Now, of course, the defendants sued them, and although you would imagine that would be a protected speech, the Supreme Court said, well, number one, we do agree that it's an issue of public interest because it's safety related, but it wasn't made during an official proceeding or an issue that's under consideration by the official body. So they were not protected at all. So the small bloggers who criticize government, I know sometimes we don't like them criticizing us, but the fact of the matter is they have a First Amendment right to do that. So, for example, if a very rich defendant were to sue that individual for making statements they consider to be defamatory and sue for an injunction and overload them with discovery requests, what that does is chills their speech. What this bill does is provide an expedited way to resolve those disputes. The court would have to make a determination whether or not the statement is protected. Now, the other section that I want to point out to you in this case, in the bill, is the automatic fee shifting provision. I think Chairman Willard had alluded to this. If you bring a frivolous lawsuit to try to chill someone's speech and lose, then they are liable for attorney's fees. That's a simple proposition. So don't bring frivolous lawsuits trying to chill somebody from saying something of a public interest and concern. Now, the amendment, with all due respect to the sponsors of the amendment, I'll point out two things. Number one, with respect to the procedures in lines 32 to 38, you already have that in current law. You don't need this new language in here. You could do this. You could actually move to dismiss the action and submit affidavits and things like that. Matter of fact, the amendment goes further here in line 39, strikes the word verified and tries to incorporate the dismissal and the remedies that the court could grant. The verification in this provision that they're striking was designed for the court to punish those who lie under oath. So what they're saying is it's okay to lie and make allegations under this amendment. This is a poorly drafted amendment, and what it does is guts the purpose of the bill, which was to expand your First Amendment rights and expand the First Amendment rights of the ordinary citizen. Mr. Chair, if there are no questions, I'll yield the well.
You do have one question if you care to yield.
I yield.
Chair recognizes Representative Trammell to your left for a question.
To the gentleman in the well, will the gentleman yield?
I do.
Isn't it true that the amendment, if adopted, would weaken the anti-SLAPP protection that we presently have under Georgia law?
That's absolutely true, Representative Trammell. Matter of fact, you and I and the subcommittee and the full Judiciary Non-Committee is very cognizant of that, and we had many, many hearings and language discussions and debate about that, and that's exactly what this amendment would do. It would weaken the First Amendment protections. Mr. Speaker, I hereby yield the well.
Gentleman has yielded the well. The chair recognizes Chairman Setzler to speak to the bill.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, I don't know that I can add an awful lot that Vice Chairman Pack didn't offer, but I do want to say this. This is an issue that was very, very carefully studied and vetted in committee. We had 4 hours of subcommittee hearing on this bill alone and took 7 substantial amendments to get it exactly as we would want it. We have an anti-SLAPP statute in place in Georgia today, but it's almost 20 years old. And as we've seen this issue progress over the last 2 decades, there's a recognition we need to do some updates and make the umbrella of these provisions apply to more people and to more cases. There are many circumstances where our existing anti-SLAPP statute wouldn't protect a First Amendment speaker, whether they're a journalist, whether they're a motion picture company, whether they're a whistleblower or whoever. This bill provides the kinds of protections that we would expect our citizens to be able to enjoy. I will say this. I don't know who's going to come speak after this or speak to the amendment, but I will tell you this. This is not just about protecting big motion picture houses. This was brought by the Motion Picture Association of America, but the bipartisan effort in the Non-Civil Judiciary Committee to perfect this bill that you have before you is a result of not just protecting big interests, but the little guy as well. As we were looking at the attorney's fees provisions of this bill in committee, the thing that kind of cemented to me that the bill as presented before you today, without an amendment, was the right answer, was candidly a liberal blogger. He came to our committee and said, you know what, I blog all the time. I do a very good job of what I do, and whether you agree with my politics or not, there are people just like me who are journalists who do our business and don't have deep pockets, and we can be shut down by the people we speak about if we don't have the ability to go to court and make a motion to strike a lawsuit against us where we're clearly within our First Amendment rights to be speaking. The bill presented to you, as presented, protects the First Amendment rights of people, whether they're big motion picture companies, citizen advocates, whistleblowers, or the small guy in your community. And I think it's very important that we continue to have an anti-SLAPP statute so that First Amendment speech is protected and can't be overcome by lawsuits from powerful interests that can come at them from every direction. I would ask you to vote down the amendment and vote in support of HB 513.
Chair recognizes Representative Evans to speak to the bill and the amendment.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, I rise to oppose House Bill 513 and to speak in favor of the amendment that is on your desk. I'll back up for just a second and talk about why we're here. First, the First Amendment. We all have an interest in protecting the First Amendment, and no one is trying to say otherwise. I certainly am not. But the First Amendment does not protect, and I don't think anyone in this room would want to protect the right of someone to lie about us, about business owners, about other citizens throughout the state of Georgia. There is no public right to lie. The First Amendment does not protect that. And so that's where the tort of defamation comes into play. When someone tells a lie about you that harms you in your profession, that accuses you of loathsome diseases, and there are a couple of other things that qualify as defamation, you have a right to protect your reputation and file a lawsuit. Has that been abused in the past? Yes, it has. And one area that was identified a couple of decades ago was public participation, folks going out and talking to their legislative bodies, talking to their city councils, talking to zoning boards, speaking out about things that were going on in their community that they did not like. And what started to happen was powerful developers and other folks who didn't like Joe Citizen speaking out about what bills were happening in his neighborhood, those big interests started suing Joe Citizen. And so you started seeing anti-SLAPP statutes pop up across the country. We have one here now. Regardless of 513, we have an anti-SLAPP statute. About half the states have them. SLAPP stands for Strategic Lawsuit Against Public Participation. And what anti-SLAPP statutes give is protection for those defendants who are being sued by folks who don't want them to speak out. And that gives the little guy, so to speak, the right to say, I want to strike this lawsuit because it's a slap against me, SLAPP. Our statute in Georgia right now says that if you are going to bring a lawsuit against someone that could be considered a SLAPP lawsuit, you as the claimant and your attorney, if you have an attorney, have to file an affidavit to verify that it is brought in good faith, that you have a good faith claim, and that it's not meant for harassment's sake. And if you are found to, at the end of the day, if on motion or the judge on his own accord finds that that's been violated, then you can be sanctioned for that. I want to be clear, there is no intent in the amendment to make it easier for plaintiffs to bring defamation lawsuit. And in fact, I worked really hard to try to bring my amendment in line as close as possible to the good that's in House Bill 513. Let me be clear, 513 takes out that verification. 513 takes out the verification. My bill was trying to mirror that part. And both what 513 does in lieu of the verification, it says if someone says that you have violated anti-SLAPP, you, plaintiff, are going to have to go to court and prove that you have a likelihood of success on the merits of the claim. Not that you have to go forward and say that you weren't slapping, you weren't violating this anti-SLAPP statute, but that your claim, your underlying claim, has a likelihood of success on the merits. That is a standard that we don't have in our law for plaintiffs to continue with their lawsuit anywhere. The only time we require a plaintiff to show a likelihood of success on the merits is if they are asking for a temporary injunction to hold money aside until the lawsuit is over, or to stop certain behavior until a lawsuit can be decided. And even if a plaintiff can't show a likelihood of success on the merits to be successful on the injunction, the plaintiff still gets to go forward with their lawsuit on the merits to develop a full record. What this statute, what House Bill 513 does, it says that plaintiff on day one of their lawsuit, before they've ever had a deposition, ever requested a single document, can't prove a likelihood of success on the merits, they are done. Period. That's different than anything we ever have in our law, and it's different than anything you're going to see in other anti-SLAPP statutes. Now, anti-SLAPP is a good thing. Anti-SLAPP, again, what I said, was meant to protect Joe Citizen. You heard from the bill sponsor and all the speakers that have come up here. We're only considering House Bill 513 not because the little guy said our anti-SLAPP statute isn't big enough, isn't strong enough, and not because bloggers said that they weren't getting adequate protection under our current anti-SLAPP statute, but because the film industry wants greater protections against defamation lawsuits. Ladies and gentlemen, anti-SLAPP statutes were never meant to protect big media. They were never meant to protect the film industry. They were meant to protect folks who were going forward and trying to have their voice heard on voices of public concern. And the reason that you haven't heard from bloggers that our current statute is not good enough for them is because it does protect them. With all due respect to the speakers before you, have heard that people are saying, bloggers may be saying that they get threatened with lawsuits, but I have yet to hear someone say that they're actually having these lawsuits filed against them over and over and over again, and they don't have adequate protection under the law. And the reason for that is if you look at line 76 and 76 to 78 of House Bill 513, which is current law, our anti-SLAPP statute protects any written or oral statement made in connection with an issue under consideration. Not in connection with a legislative proceeding, not in connection with a court proceeding, but in connection with an issue that's under consideration by a legislative body or under consideration by a court or any other official proceeding authorized by law. So if someone wants to talk about Representative XYZ and what that person did or didn't do, that is already protected under anti-SLAPP. There's been a concerted effort across the country for the movie industry and for media defense firms to try to bring the movie industry, to try to bring the media underneath anti-SLAPP statutes that were never meant to be about them. The amendment, I honestly think that our current law is plenty adequate, and I haven't heard an argument otherwise, but in order, if there are folks who think that we do need to tighten up a little bit, that was the purpose of my amendment, to, instead of just simply requiring the verification, to make a place for this expedited resolution of the claim that is put forth by 513, but without that overwhelming burden to show likelihood of success on the merit on day one of your lawsuit before you've ever had any discovery. And the reason that that's so important, especially in a defamation lawsuit, and this could affect some of y'all personally, it would affect any most prominent business folks out in the community or anyone considered to be a public figure. If you are defamed, if someone tells a lie about you and you try to go and remedy the harm against you and you try to file a lawsuit to protect your reputation, you as a public figure have to show actual malice. And that means that the defendant knew or was reckless in not knowing that what it said about you is not true. That is a very high standard and is very difficult. Defamation law is very difficult for plaintiffs. How are you going to prove state of mind of the defendant without being able to take the defendant's deposition? 513 stays discovery pending this motion to strike, where you as the plaintiff have to show likelihood of success on the merits, and we're not going to give you a single tool to do it. The bill was modeled after California's law. And here's something very important. I know that this is dry as it can get, and I'm sorry. But it's important, and I thought I needed to come up here and tell you what I knew. So California law, our law, the law that's being proposed today would mirror closely to California's law. But here's what happened in California a couple years after its anti-SLAPP statute was in place. California introduced passed another statute and specifically said this in the statute. This was not just something that's said in a committee meeting. This is in the law. The legislature finds and declares that there has been a disturbing abuse of our anti-SLAPP statute. Particularly, it found that disgruntled employees and competitors of businesses were going out and finding reporters who are, in this 24-hour news world that we live in, always fishing and looking for stories, and they were finding those reporters, and those reporters were writing stories on behalf of their competitors to talk about how bad their products were or that they were harming the consumers. And then when those businesses tried to do something about it, they were getting served with motions to strike under the anti-SLAPP statute. And California legislature came back and said, that's not what we were trying to do. We were not trying to give way for competitors to go out and defame their competitors, or for disgruntled employees to defame their employers and have this rampant abuse. And so it made a lot of exceptions that you will not find in House Bill 513. So what is being proposed to you is something that has already been found not to work. Defamation lawsuits, and I've said this, they're hard already. There's a lot of protection out there. Opinion is protected. There are all sorts of safeguards in place for a defendant already. And with all due respect to the presenter, the lawsuit that was up on the screen, not only, as Chairman Willard pointed out, it was in Florida and not here. That's a misappropriation of likeness lawsuit. That was not a defamation lawsuit. I can't see in any way that what we're passing here today is going to make that any more or less likely. And I just want to leave you with just some thoughts. Reputational damage is real. I've sat with business owners who have had businesses that they worked decades to build and reputations that they've spent decades to build erased in a second by a news account that was fed to a reporter to defame that business owner and cut them out. And there's a lot of times, even when that happens, there's very little protection. But what's going to happen now, because of the way that 513 is structured, not only because of this very high burden at the beginning of the lawsuit to prove a likelihood of success on the merits, but also because of the additional language added on lines 79 and 80 to expand the definition of what's covered in an anti-SLAPP statute to include basically anything that's stated in public. Not just someone going forward and trying to make their voice heard and trying to make their community a better place and being afraid of being struck back against on that, but basically anything that someone says. And that is, again, not what the anti-SLAPP statutes were ever meant to do. And I think it's too broad and not something that this legislature should endorse. So I'm sorry, again, that it's so dry and that I've gone on so long, but I'd be glad to take any questions, Mr. Speaker, if there are any.
You do have a question.
I yield.
Do you yield?
I do.
Chair recognizes the chairman of the Transportation Committee, Chairman Coomer, to your right.
Thank you, Mr. Speaker. Does the lady yield?
I do.
Thank you very much. Are you familiar with the presidential candidate named Donald Trump?
I am. My daughter is too, which is very strange. She talks about him all the time.
Would you further yield?
I do.
Are you aware that Mr. Trump recently said he'd like to tighten up libel laws in this country so that he could be a smaller target of attack for news media outlets?
I was not aware, but I'm not surprised.
Well, if you assume that he did say that, would you then agree that he would probably be opposed to your amendment? And I would support your amendment.
I think
I don't
he
mean
would
to
be
confuse you with that
opposed. Yeah.
question. I'm sorry about that.
I think he would be opposed.
Thank you.
Anyone who wants to stop the truth would be opposed. I'd be happy to yield for any other questions if there are any.
You have no further questions.
Thank you, Mr. Speaker. I yield the well.
Lady has yielded the well. Is there objection to the previous question being ordered? The chair hears none. The previous question is ordered. There is an amendment. It is the Evans Amendment, AM 292518ER. Clerk will read the amendment.
Representative Evans, the 42nd, offers the following amendment, AM 29251-8ER, which is printed and distributed on your desks.
Is there any objection to adopting the Evans Amendment? Is there objection? There is objection. Does the lady move? The lady moves. All those in favor of adopting the Evans Amendment will vote aye. Those opposed to the Evans Amendment will vote no, and the clerk will unlock the machine. What purpose does Representative Fleming rise?
Parliamentary inquiry.
State your inquiry.
What is the other name in front of Ms. Evans on the amendment?
Well, the chair, it's Stacy.
Thank you, Mr. Speaker. I thought it was somebody else.
Would the lady agree with me? She agreed. It is the Stacey Evans Amendment. All those in favor of the amendment are voting aye. Those opposed to the amendment are voting no. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the adoption of the Evans Amendment. The ayes are 71, the nays are 98. The amendment has failed. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 513 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 513. The ayes are 131. The nays are 41. This bill, having received the requisite constitutional majority, is therefore passed. The chair recognizes the chairman of the House Rules Committee for an announcement. You get no love unless you got a bill left in rules.
Thank you, Mr. Speaker. I heard someone earlier mention about the SOB. Well, he's here. And I remember every one of y'all. There will be a Rules Committee meeting immediately in 341.
The posture we're in, we still have only a very few measures left on the rules calendar that was published earlier for today. Those will be just so you can keep up if you're not already. House Bill 734, House Bill 779, House Bill 1060, House Bill 677, and House Resolution 807. This House will be in recess until 3:45.